to say I want to look at them one more time. I'm going to look at them one more time.
Yes, sir, and I'll have somebody, we'll have double.
All right, in fact, give me one other second. Hold on one second.
I'm okay, I'll get it. I'll get it.
Okay, sorry about that. Have a seat. It's all right. All right, so we are, yes, ma'am.
Just one thing, just the verdict forms, because they're all stapled in one pack, we're just suggesting, and I talked to Mr. Strolla, that you just advise the jury not to unstaple them, so that the second pages with different findings don't get confused.
Actually, what I did for y'all is just put it in one, what I'm gonna do for them is each verdict would be stapled together, but there'll be 5 separate
Thank you.
verdicts, if you know what I mean. I won't give them a package like that.
Well, I figured if you gave them the package, just tell them not to take it apart, but if we give them the 5 separate ones.
Yeah, I usually separate it out.
Can we clip them together, because so they're not moving around?
Yes.
Thank you,
Yep.
Judge.
what I might do is let the jurors have a set like that to go along with their jury instructions, but I will have the original set of verdict forms that will be each one separated, but where it's 2 pages, it'll be stapled together, so the second page won't get mixed up.
Thank you, Judge.
But thanks for bringing that to my attention. I typically do that, but I'll make sure I don't forget. All right. And then at our next break, we can take another last look at these to make sure we haven't found any other difficulties or problems. Okay, other than that, we ready to proceed from Mr. Strolla?
So ready, Your Honor.
All right, bring the jurors on in.
Jurors entering courtroom.
All right, thank you, ladies and gentlemen. Welcome back. You can have a seat. Hope lunch was good for you today. We are ready to resume, and we will hear from Mr. Strolla on behalf of the defendant, Mr. Dunn. Mr. Strolla.
Thank you, Your Honor. If you may please the court.
Yes, sir.
Opposing counsels. Good afternoon. It's always the fun pleasure of talking to you at the end of 2 weeks of trial and you just had lunch. I will not scream at you or raise my voice at you, but I will ask you to pay close attention. The good thing is you will have a copy of the jury instructions provided, each of you. I'll refer to pages. So don't feel like you have to take notes and try to write definitions down and things like that. You'll have the legal doctrine. You'll have the law. You know who else has the law? That man right there. He's got every protection under the law that this country provides. He has every right, every protection, and the only people that can take that protection away is at this table right here. We talked about in the very beginning, what does a grand jury indictment mean? It means nothing. We talked in jury selection, no judge, no defense attorney. It's a secret proceeding. That's why you have an expression, you can indict a ham sandwich. All it is a piece of paper, an accusation, a limited amount of evidence to form the minimum amount to charge somebody with a crime, whether they committed the crime or not. Now, who's got that burden to prove the crime? Right here. Remember, that gorilla never moves. That boulder never moves from this table from day one to now to when you're in that jury room. That burden never shifts to Michael Dunn or this table. We don't have to prove a single thing. It's the state's burden. And you know what you're going to learn from Judge Healy? That the law of justifiable use of deadly force is the state's burden to disprove, beyond and to the exclusion of every reasonable doubt. Think about that. They've got two burdens to carry. You cannot lawfully convict any human being unless every single element of the crime is proved beyond a reasonable doubt. And Judge Healy's going to give you an instruction that says, how do you prove it beyond every reasonable doubt? It comes from the evidence. It comes from the lack of evidence and conflicts in the evidence. Does it come from Michael Dunn? Absolutely not. How many times did Miss Wolfson get up here and say, the defendant, the defendant, the defendant, he's got a name. His name's Michael Dunn. But to dehumanize him, he's a defendant. To make you not think about it, he's a defendant. And we understand so is Jordan Davies. We understand he's a human, and it was a tragedy. Mr. Dunn is not here to say that it's not. He's not here to change the law. He's here with his constitutional protections that wrap him in a blanket with our flag. And that blanket can never be unwrapped unless the evidence overcomes it to an exclusion of reasonable doubt. Like Mr. Guy said in opening, we're going to prove it to you beyond any doubt. And he said it over, and he said it over, and he said it over. Now let's look at what Mr. Guy said in opening. He said he's going to prove to you beyond any doubt with physical evidence that the defendant used words of hate. Did you see one single witness from the state attorney's office called to that stand under oath that said that Mr. Dunn used a single word of hate? Zero. But they want to throw it at you that, I hate that thug music. Gassed. Michael Dunn's blood was boiling. He had just come from a wedding, from his son, with his fiancée and his family. And you even saw his ex take the stand and tell you he was welcomed with open arms, like he's never been away. He was in a good mood. He told the officers on video, I have everything good in my life. I'm not looking for trouble at all. Why would I do that? So the only word of hate Mr. Dunn used, according to Mr. Guy, is about music. Well, I asked his son, Chris, did he push over the DJ table or tell that guy to turn it down? Nope. Did he storm out of there when he played music that the kids listened to? Nope. How about his ex-wife? If someone's going to hate you, it's probably going to be your ex. And his ex-wife even said he was polite, pleasant, cordial. No issues of impairment. No issues of anger. But his blood was boiling. He was so mad he grabbed his gun and he pumped lead into that truck. No matter how much Miss Wolfson wants to raise her voice at you, no matter how much she wants to yell about the facts of this case, not a single witness or evidence suggests any anger or any hate from Mr. Dunn towards anyone. Now look at the guys in the truck. Even they admitted on cross-examination. Did you see him get angry? No, sir. Did you see him curse? No. Did he punch anything, throw anything? Nope. But they want you to believe they saw his mouth move, asking him about the music. And that's what led to a confrontation, according to the state. Well, guess what, members of the jury? This is not the media. This is not the public. Those doors stay shut. You have to listen to what you heard on that stand, and that stand only. Before you can even look across to Mr. Dunn for guilt, they've got to overcome it with their evidence. Not emotion, not anger, and not sympathy. Judge Healy's going to tell you that if you use that, if you form any verdict other than not guilty, and you use those factors, that is a miscarriage of justice. And you can't do it. It's a violation of our laws. And everyone agreed they'd follow the law. And you're going to get that. And I'll go over it. But you have to look at the evidence for what it is. Now, Miss Wolfson stands up here and says, look at the inconsistencies. He said thug music. He says rap crap. We're playing semantics. And we're playing semantics with a man on trial for murder, attempted murder, shooting into an occupied vehicle, and trying to convict him for something he didn't do. For being so angry, the guys in the car even said, we didn't even see signs of anger. Now, Judge Healy will tell you, look at how they answered questions. Look how the witnesses responded, not just what they said. And what did I ask you in jury selection? Can you focus on cross-examination? Can you keep an open mind, not just when they ask their witnesses questions, but pay attention on cross? I don't want the spotlight or attention, but I wanted you to notice. Did you notice how their witnesses changed? How many times did the state's witnesses get up there and say, yep, nope, yep, nope, yep, nope, that's true, that's not true? And when I got on cross-examination, I had to ask their witnesses 2-3 times. Detective Musser, the medical examiner, every other witness. I'd have to ask 3 times just to say, so the answer to my original question was yes. Why would a witness do that? Because they've got an outcome and interest in this case. And we've already seen people who got benefits from the state. We saw witnesses get up there who asked for benefits, received benefits. Sean Atkins wanted to stay here after his deposition. Lasted 15 minutes. He stayed here for over a month. And Miss Corey gets back up on redirect and says, oh, but don't you lose your game time in prison, sir? Oh, yes, I do. Who cares? He asked for the benefit. He didn't care about game time, but he's going to make Miss Corey happy with his answers, isn't he? Why? How many people convicted of felonies don't want to go back to prison and stay here every day and are told by the sheriff's office, bye, have a nice time in prison? And what does Mr. Atkins get to do? No, you can stay here for a month, it's okay. You're our witness. Look at Mr. LeBlanc. Look how he testified on direct examination. He had it down. Yes, no, this is what I saw, this is what I didn't see. On a cross-examination, 2-3 times. The answer to my question was yes, or no, or true. Why? Because Mr. Guy picks up the telephone when he's got a warrant, calls the judge and says, hey, judge, got a witness here on our murder case. He's got a warrant. Hasn't showed up for his depot. Can we do something about it? Yeah, come in next week. Warrant gone. How many people in Duval County have been picked up on a warrant? As we sit here right now, how many people are in jail on an open warrant? But the difference is, those people aren't Mr. Guy's witness. It's not Miss Corey's witness. That's a benefit. And Judge Healy will say, you can consider that. Look at Tommy Storms, an alleged victim who clearly contradicts other people's testimony, including the guys in the car. He's the one that said, oh, I called 911. Couldn't get through. They finally put his phone records in. What did I ask him? He was on the phone with 911 for 1 second. And then what does he tell me on cross? Oh, that's because Tevin Thompson was on the phone with 911, so I immediately hung up. That's not what he said on direct when they questioned him. He said he couldn't get through. So he changed his story. And then now with Tevin Thompson, when did he call 911? He told you, when I got back. When we drove all the way back to the Gate Station parking lot, I got out and called 911. And you have his phone records at 7:43. So we know that truck was gone for 3 minutes. 3 minutes. Now, why is that relevant? Do you remember Miss Wolfson telling you 10 seconds in between shots? That's a long time. It's so long, he conceived premeditation, and you have to find him guilty. It took 1:38 from the time he walked in and the shots. That's a long time. This argument went on for 1:38. First of all, an argument takes 2. An argument goes back and forth, and not one single witness took that stand under oath and said this man yelled anything back at any time and showed any signs of anger, including Tommy Storms, who walked right in front of his car. That truck was gone for 3 minutes. 2 minutes. There was no weapons found in that truck in that 3 minutes. Where was that truck? It left the scene. And who knew it left the scene? Michael Dunn didn't keep it a secret. There were a host of witnesses, as Mr. Guy put in opening statements. A host of witnesses at the gate gas station that all told the detectives the SUV left. We had 2 911 calls. We knew exactly where the SUV went. Did the 3 men in the car tell the police where it went? Nope. Did the 3 gentlemen in the car tell the police where they stopped? Nope. Did they tell the police they got out of the car and started getting stuff out of the back? Or stashing something, as Mr. LeBlanc put on 911 that night? No. And did Detective Musser ever order any extra security? No. Did the detectives close the plaza down? No. Did they secure the scene? Oh, they secured the truck. Because every question Miss Corey asked of every witness, was there a weapon in that truck? Not when they found it. Not when they saw it. And who else was on scene within minutes? Tommy Storn's cousin. It was so important to hang up on 911 to start calling his friends and calling family to come down. But Mr. Guy tells you they do a roll call. They call out to all their friends. And Mr. Guy said he was going to prove beyond any doubt that when they knew Jordan Davis was hurt, they called 911. No, they didn't. Not a single guy in that car called 911 until Tevin Thompson, back at the gate. Listen to the 911 calls. They're in evidence. You'll hear them. Can you send the ambulance? My friend shot. And you will hear zero panic in his voice. Almost zero distress. And ask Detective Musser, when you go back there and you deliberate, why didn't you bring a canine to look for the gun? They have what's called article searches, where canines are trained to find weapons and drugs. Why didn't you go search the plaza where the SUV was? Why didn't you secure the plaza? Because now we've got 2 crime scenes, don't we? We've got the gate gas station, and we've got where the SUV went and got out of the car. And we know they got out of the car because 2 independent witnesses saw them. And what did Detective Musser say to me? It's not my job. Not my job. You remember when he walked around the scene and he did his walkthrough with Technician Kipple? It's not his job to point out evidence. But when I questioned Technician Kipple about missing bullet fragments, blurry photos, no, not my job. I didn't do that. Nope, not my job. When I asked their own expert medical examiner about the toxicology of Jordan Davis, no, not my job. I don't verify it. And what did their experts say about the toxicology? It was handwritten on a piece of paper. And she just put it in her report. Did you get a primary source report? Did you go verify it? Nope. You just relied on somebody handwriting on your piece of paper it was negative. Yep. Why wouldn't you go research it? Why wouldn't you go verify and look at a report that a scientific instrument should kick out in every case? It's called a gas chromatograph mass spectrometer. Shands Hospital have them. The toxicology has to have them because that's how they test it. And what did the doctor say to me? Not my job. And that's what they want you to convict someone on. That's not your job. It's not your job to make up for their case, the lack of a case, and the conflicts in their case. And I find it ironic that Ms. Wolfson can stand here with a straight face and tell you that it's okay for her witnesses to have inconsistencies. It's okay for their evidence not to match up. That's real life. These are real people who aren't trained witnesses. It's good for them, isn't it? Who is it not good for? Why is that? You know what they charged him with. Judge Healy read the indictment. But now in the instructions, you're going to get lesser included offenses. Because what the state says is, hey, all right, we may not be able to convict on premeditation. We get it. But there's second-degree murder.
Sustained.
You will be asked to convict my client of lesser included offenses. Why? Because if you don't feel the state met their burden, they're going to ask you for a lesser. And if you don't believe he committed second-degree murder, a depraved mind, well, we're going to ask you for manslaughter. And Ms. Wolfson glazed over justifiable use of deadly force. What she didn't tell you is, it's their burden to disprove it. That's right. We talked about the two burdens, just like the two crime scenes. So don't let them get up there and tell you it's not their job. It's all their job. Just like the detectives, just like the technicians, just like the witnesses. Now, there was a video you saw at the end. Watch it again. Watch my client testify over and over. Watch it 100 times if you like. He never wavers until the detectives tell him, we searched the entire crime scene. There's no weapon anywhere. Is it possible it was something else? It's possible, but I know what I saw. But what does Mr. Dunn believe? That they searched both crime scenes. The detectives tell him, we searched the area. No, they didn't. And what does Detective Musser tell him? I understand it because believe me, we deal with guys who you ask them to turn down the radio. They would get out of the car and shoot you. We deal with those kind of dudes all the time. That's on the video. Detective Musser's own words. We would have a different argument from Detective Oliver had anyone been out of the truck walking towards you or any type of threatening manner. We would have a totally different, and then he gets cut off from the other witnesses. Oliver further goes on to say in the video, if there was a shotgun coming at you, we would expect you to do what you did. The problem that we have is there is no shotgun. That's the bridge that we got to get across. What's Detective Oliver doing? Shifting the burden, isn't he? What did Detective Oliver not tell him? All my partner did was stand there for 15 minutes with Technician Kipple and say, all right, photograph the casings, the car, the jacket on the ground. I'm going to go talk to the witnesses inside. Do you remember Technician Kipple telling you that? They did a walkthrough, lasted about 15 minutes. And I asked them, what did detective point out to you? You're the primary major case technician. This is Technician Kipple's case for evidence. Did he show you anything else? Nope. Did you go seek out anything else? Not my job. Did Detective Musser ever tell you to go to another scene? No. And what did Miss Corey ask Technician Kipple? If there had been fingerprints and you were told the shooter touched that truck, would you have fingerprinted that truck? Oh yes, that's part of my job, I do it. And what did I ask him on cross-examination? If you knew there was a second crime scene, would you have gone and processed it? Yes, I would. Were you told that? No, I was not. You keep dwelling on this shotgun as if there was one at the scene. Okay, here we go. Detectives are talking about the scene, not just the truck. How many times did the state ask their witness, was there a weapon in that truck? Was there a gun in that truck? Was there a weapon? Truck. Never asked about the plaza. Never asked about underneath the cars in the plaza. Never checked the bushes. Never checked the dumpsters. But you know when the detective alleges they did it? 5 days later. They're on scene on November 23rd. So you got the night of the 23rd, no search. November 24th, no search. November 25th, no search. November 26th, no search. November 27th, I get the detective to admit they had a brainstorm session. We got all our partners in together. We sat down to talk, what do we need to do next on this case? Let's go search the area. Let's go send a helicopter up, because I know a defense attorney is going to ask me, did I check the roof? Because who said that? Remember Detective Musser? They laughed about it. Him and Miss Corey were laughing. Or Mr. Guy. You went up there and checked the roof. Why? There were no guns. That's 30 feet up there. I asked them, then why'd you check? If it's so unrealistic, why'd you check? Because I knew you were going to ask. Did you hear me ask one time, did he search the roof? No. And look at the photos the state gives you. You think they're going to find anything 1,000 feet up? They didn't send that helicopter up to go look for weapons. They were doing a major case, get pictures of the crime scene so we can show it to a jury and prove our case. There wasn't a weapons search. And then Detective Musser tells you, oh, some other detectives went there and they did it. Remember I said, where in your report does it show you checked the dumpsters? Oh, right here. One of my detectives did it, remember? Did it on purpose. Because then I asked him, what day was it? November 27th. That evening, after their brainstorm session. But they didn't go there to check for weapons. Because how long were the detectives on scene? I got him to admit 40 minutes. 40 minutes. And why were the detectives there? To ask every individual plaza store about a video. And I think the detective added up to about 17 different units. They were on scene for 40 minutes. If the detective spent 2 minutes in every one of those stores, you're almost at 40 minutes. So now they want you to believe that they checked all the bushes and dumpsters prior to that. And where did you see those pictures? Who showed you pictures of those dumpsters? Who showed you a picture of those bushes? Who called the witnesses to the stand to talk about dumpsters behind the plaza, behind the stores? Not one single witness for the state pointed it out. Not one. I called Michelle Reeves. She was one of the girls working in the dry cleaner who said, yeah, they came and talked to me for about 10 minutes. Well, now we're down to 30 minutes, folks. We're not at 40, we're at 30. And that's one store out of 17. I called Darian Yates. I had him show you where the dumpsters are. And they got to walk all the way around the store to get to how many dumpsters were behind that store. I think Gate had 3. And then you had a couple over with the other plaza. But why would Detective Musser want to tell you that they did such a thorough search? You know why? Because they knew they messed up. They knew a defense attorney was coming. They knew they had to answer, and the state knew they had to meet their burden. But we don't want you to focus on that. Be mad at that man. He's an angry man. His blood was boiling because he asked for a common courtesy that he does all the time in Satellite Beach where he's from. And he's dealing with guys in the military at the Air Force Base who are probably some pretty big dudes. And what do? Oh, sorry, we'll turn it down. What did he tell the detectives in the video? When they questioned him about it, he even said, I can't understand it myself. All I did was ask for common courtesy. And he became so irate and so agitated and so violent. And then he pulls a weapon. And he knows what a shotgun is. You even heard his witnesses come in who told you. We know what his reputation for peaceful is. We've known him for 10 years. His friend, the other computer programmer, Don Mays, he's known him for 20. This man's got a reputation for peacefulness, not only in his community at home, but at work. For 20 years. But now, his blood's going to boil because a teenager tells him, F you? Does that make sense? Is that reasonable? A man who's never pulled his gun in 40 plus years, who has a concealed weapons permit, who can carry it right next to him, chambered, ready to fire at a drop of a hat. What does Miss Wolfson tell you? It's in his glove box, in a holster. He's got to take the safety off, and then he racks it in a round. Sounds like a madman to me, doesn't it? Wow, he's out of control, folks. And what did he tell you? He's had that gun for 20 years and never pulled it once. And he shot it. He told you, I shot it at the target range. I go there. And he even told you, I thought I was prepared. I thought I could handle myself. And then he told you what he went through after the incident, that nobody has ever scared him. Nobody has ever threatened him like that, and he's never been in that situation. And you saw Miss Rower confirm that. And interestingly enough, Miss Wolfson and the state, they hang their hat on Miss Rower. Well, she told you Michael didn't say that. She told you Michael didn't hear that, right? But what did Miss Rower say? The way you saw her today on that witness stand, hysterical, shaking, when she took her oath to this clerk, did you watch her tremble? They're not in fear for their life in this courtroom. They're not running from anybody, and she was still that scared. When she got down off that stand, she had to be escorted out by a bailiff to walk. And I asked her, are you more emotionally okay today? Are you more stable today on that stand than you were that night? And she said yes. But the state wants you to believe she saw everything clearly, she heard everything clearly, she has a perfect memory. And I asked her, is it possible Mr. Dunn told you he had a gun, or there was a gun? She said it's possible. Is it possible he called Ken and you just remember the phone call? It's possible. Think about that. If she was more emotionally wrecked on November 23rd and 24th, compare that to what you saw on the stand. That was calm compared to the way she was that night. But again, the state tells you, well, it's okay if our civilian witnesses don't remember everything clearly and it's inconsistent. Mr. Dunn's not a law enforcement officer. He's not an ex-veteran or military. He's not a trained witness. He's not an expert witness. He's not a professional witness. He's never been interrogated by the police. And yet the state keeps calling it an interview. Watch the video. They're not asking him questions. They already had an arrest warrant for murder that this prosecutor helped him fill out and got signed the night of the shooting, where they had 3 people in a detective's room to take audio and videotape statements. We would have seen exactly what the boys looked like and said. We would have known everything they said and did not say. All Detective Musser had to do was ask his supervisor, did he do it? No, not our policy. We don't do it. And I got him to admit, well, wait a minute, you did it for Sean Atkins. Oh, Miss Wolfson wanted to take a sworn statement. That's why. And I got him to admit, the prosecutor can overrule them and say, no, I want the video and audio on. I'm going to take a sworn statement right now. We know they can because they did with Sean Atkins. And I think what Miss Wolfson didn't realize is, this kid's going to become a multi-convicted felon by the time we get to trial. He's not going to ask for a favor. Can I stay in Duval County? I don't want to go back to prison. And we would have seen exactly what Tommy Storms would have said, Leland Brunson and Tevin Thompson. Matter of fact, they got interviewed a few days later. 4 days later. Before they even searched the scene for weapons, they had talked to the guys again. Was it taped? Nope. Was it recorded? Nope. Was it sworn? Nope. And who did I call as a witness to talk about what those boys said? And I didn't enjoy doing it. I didn't want to. But Mr. Ron Davis gave a deposition in this case. And my question was very clear. Were the boys there a few days after talking about what had happened that night? And his answer was, and I read it to him, they were still in shock. They all had something a little bit different to say about what happened. The police didn't bring that evidence in. The state didn't bring that evidence in. But again, Mr. Dunn doesn't have to prove anything. He is innocent. Innocent, not even not guilty. He is innocent under the law until the state and the state alone's evidence can overcome it. And I'm not even at self-defense yet. I haven't even started talking about self-defense yet, have I? Let's look at the testimony of Tevin Thompson. Mr. Dunn didn't say anything to make him angry, didn't look angry, didn't act angry, and didn't curse. In fact, the only one cursing and getting angry was Jordan Davis. He could hear the F-bombs being said. He could hear the curse words, but he wouldn't admit to the threats. And what did I get him to say on cross-examination? There were some points I couldn't hear what he was saying. The music was loud. They're sitting a lot closer than you and I. But yet Mr. Thompson claims, nah, he said some things I couldn't hear. Is it possible he threatened them? It's possible. But you couldn't hear him. Nope. He was on that witness stand. I said, he's sitting right behind you. Jordan Davis was right behind you. You couldn't hear him. Nope. Leland Brunson. Same questioning. Yeah, he was cursing. He told him, I'm sick of people telling me what to do. F him. And matter of fact, Tevin Thompson even said Jordan Davis used an N-word in anger. And I made sure that wasn't Mr. Dunn. There was nothing of hate coming out of Mr. Dunn. There was nothing of anger of Mr. Dunn. And even Leland Brunson said, and I asked him, have you ever seen him that mad before? Yes, I have. And he was yelling. He was yelling. He was angry. He was angry. He was throwing F-bombs. Yes, he was. Did he threaten him? Oh, couldn't hear everything he said. Couldn't hear everything. Is it possible he threatened him and you didn't hear it? It's possible. Isn't it interesting that all of the guys in the car heard everything that Jordan said, but when you ask them about to verify what Mr. Dunn said, I couldn't hear him. They didn't say he didn't say it, because they said that on direct. I got them to admit he was still yelling things that they couldn't hear. And I even asked Leland Brunson, his best friend of 2 years, you were sitting right next to him, right? I was right next to him. You were focused on what's going on. Yeah, I was watching, and we know he was watching, because Mr. Dunn said I could see him sitting right next to him. I could see the 2 guys in the back of the car. And Leland Brunson admitted that Jordan was yelling, but couldn't hear everything he said. Why? Do you remember what Leland Brunson said to me? He said, you don't want your friend to die in vain, do you? No, I do not. And I feel for him. We all have friends. Nobody wants to lose a friend. But you certainly aren't going to be the one to basically admit, my friend was out of control. My friend did grab a weapon. My friend did get out of the car. My friend did threaten him. Because you know what would happen if he told the truth? This case never comes forward. How do we know that? Because Detective Musser and Oliver said, had anybody gotten out of the car, it'd be a different story. Had anybody had a weapon and threatened you at all, this would be a different story. Matter of fact, Detective Musser says we have clear-cut cases of self-defense all the time. And we say, thanks, have a nice day. Watch the video. It comes right out of the detective's mouth. And Detective Oliver says, had we found any weapon inside that truck, you would have been able to cross that bridge, Mr. Dunn. And then you and I and Mr. Dunn would never have met. But it's not their job, right? That's what the detective said. I didn't put words in their mouth, and I said that on almost every witness. Is it fair? Is it accurate? Am I putting words in your mouth? And not one witness said yes. Watch how many times they talk about no weapon in the truck. Think to yourself how many times Miss Corey said, was there a weapon in that truck? She even asked Detective Kipple, did you search with great care? Oh, yes, I did, Miss Corey. And what did Kipple do? Well, he missed a bullet in the car because they found it a week or two later. He took a blurry photo of the child safety locks and said, oh, that wasn't me. That was Technician Whittlesley. When he went with Oliver and Musser, because they were checking the child locks, remember? They went back and asked the boys, are the child safety locks on? Yes, 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 they are. Nobody can get out of that car from the back. You've got to open it from the outside. Do you remember their boys testifying to that? Do you remember Leland, Tevin, Tommy, all trying to talk about that? So what does Detective Musser and Oliver do? They call over another technician, Whittlesley. Open up that car. Open it up. And the child safety locks are not engaged. And the state had one blurry photo. And nobody wants to admit whose it is. Kipple says Whittlesley. Whittlesley says Kipple. Whittlesley even said, I didn't even watch what Dunn and Oliver did. I was just standing there. What does Whittlesley say? Not my job. It's not my case. And what does Detective Oliver Musser say? Musser gets him on the stand and says, oh no, Detective Oliver, he sat on that seat, he tried to reach under there, we couldn't get that tripod, we tried it that night. That's what we were there for. And we were looking at the child safety locks. And I asked Detective Musser, show me in your report anywhere that Oliver did that you guys checked that seat and you tried to reach for weapons and you couldn't do it. And this is what you saw. It's not in there. Nobody put it in there. I called Detective Oliver. He didn't put it in there. And I got them both to admit, in your training and experience, are you told to put relevant facts in your report? Yes, we are. It needs to be complete and accurate. Yes, it is. And you didn't do it. Nope. Isn't it amazing after the defense has perfectly clear pictures of what's underneath the seat of that car, that there's room for a weapon, that the child safety locks are not engaged, which means the boys are all lying. Now all of a sudden the detectives do their job. Now we want to go check it out, and it's nowhere in their report. Why? Because they knew a defense attorney was coming. They knew what was coming. It was weeks after the incident they checked it. And yet the state didn't give one clear photo of it. Look at all of their pictures. Go through every beautiful slide that they have. And the PowerPoint presentations. It's wonderful. But it doesn't change the inconsistencies and lack of evidence, does it? They could give you every beautiful exhibit in the world. They could give you PowerPoints. They can give you a dummy. But it doesn't change the facts of the case. It doesn't change the conflicts or the lack of evidence of the case. It doesn't change the testimony. Not one photo taken by a detective or technician showed you in evidence. Not one photograph of the door locks, the safety, child safety, because let's not play semantics and I'm going to get there. Not one photo the state has is a clear photo of those child safety locks that the guy said were engaged and Jordan Davis could never get out of that vehicle if he wanted to. You won't find a single one. You'll find similar angles and it's kind of close and it's interesting how Kipple took his photos. And look at the exhibit because it's defense exhibit. They're my photos that we took. We put in evidence. Why? We don't have to prove anything. But I'm certainly not going to let a man get convicted of something he didn't do. I'm certainly not going to stand here and let people say it's not my job and give false testimony and change their story. We had state witnesses change their story from direct to cross to redirect. And the one witness the state wants to hang their hat about my client, Mr. Dunn, was angry is Stephen Smith. I heard him say, "You're not going to talk to me like that." And he said, "That's what drew my attention." Remember Stephen Smith? Well, what did he tell Detective Musser that night? The guy that did the shooting had a black cap on. I saw it. Mr. Dunn wasn't wearing a baseball hat. You saw him that night. He was coming from a wedding. He's dressed in a nice outfit, trousers, nice pants, a shirt. He doesn't have a black baseball. Nobody said. Even the guys in the car didn't say he had a black hat on. And watch the video. The state keeps showing you literally snippets and seconds of the video. Watch the whole thing. I implore you. There's a timer on it. You'll see how long it takes. And where did Mr. Smith tell you he was parked? Right out the door, first spot on the left. Right? He said about 10 feet away. 1, 2, 3, 4, 5, 6, 7. Maybe 5 seconds at the most. Till Mr. Smith is out of the store for a great length of time before the first shot is fired. But he wants you to believe. He walks out of the store, looks around, comes over by the defendant's car and stands there. "You're not going to talk to me that way." And I see him reach for a gun. That was his testimony. And the state asked him, "Did you see anybody get out of that truck?" "No, I did not." "Did you hear anything come out of that SUV?" "No, I did not." Well, if the music's not that loud where he can hear something come out of the SUV, why can't Tommy Storns? Why can't Leland Brunson? Why can't Tevin Thompson? You got a witness who's an independent witness 20 to 30 feet away from the truck who says he hears nothing, but can hear my client say that with his windows up facing the guys. Remember, everybody agreed his windows were up. The only window he put down was his own to try to talk to Jordan Davis, and he even said, "I was trying to de-escalate it." He didn't say, "You talking to me? Are you talking to me?" Tevin Thompson even said he never looked angry. Mr. Dunn never raised his voice. Leland Brunson agreed. And Mr. Dunn said, all I asked him is, "Are you talking about me?" And he was going to apologize and say, "I said thank you." Because people have been there. You get cut off. You let somebody get in. You do a common courtesy. And what does everybody wait for? You wait for that hand to come up. And if you don't get it, I shouldn't have let that person in. Look at that. I gave them a common courtesy and I don't even get a thank you back. It's kind of annoying. Does it make you want to shoot someone? Are you going to get out and start pounding on their car? And all he was trying to do was de-escalate a situation spiraling out of control. And how do we know it was? Because Tevin Thompson even admitted on cross, "I was there watching it escalate." Not Mr. Dunn, because he already admitted he never saw Mr. Dunn mad, angry, curse, yell, punch, kick. So who is he watching it escalate? Jordan Davis. And Leland Brunson said on that witness stand, if he wanted to get out of that truck, he would have gotten out of that truck. And you heard people in the gallery laugh. Do you remember that outburst? Why on earth is that funny? How is that even appropriate? And let's just assume, because I know Ms. Corey said that word literally about 25 times with her medical examiner, so I'd like to use it once. I think that's fair. Let's assume the child locks were engaged and you can't open from the inside. Leland Brunson admitted on cross-examination, not direct, cross, that Jordan Davis grabbed that handle to get out of the truck. But he couldn't. Why? The child safety locks were on. Well, what did Mr. Dunn tell you? His window was all the way down. So again, let's just assume, I think it's fair I get one, that the child locks were engaged. Doors open. And how do we know the window was down? Look at the state's photographs. Look at the SUV. Look at the front passenger window. Because Tevin Thompson said his window was up. And you'll see it shattered. And remember I asked Tevin Thompson, is that accurate? Was your window shattered that night? No. But you could see that it was up. And he said, my window was up when I was there. Look at the pictures of the back seat where Jordan Davis is. Do you remember what Tevin Thompson testified to? There was only about an inch of space for Jordan Davis to see out of. Remember that? Remember Tevin Thompson said he even leaned back over and put the window back up because he was watching it escalate? So that means, if you want to believe they're telling the truth, that window would have been up when the shots fired. There's no back window at all. And what did Miss Corey ask Technician Kipple? Did you even open the back door and take off the panel to recover the glass? Nope. Why? Because when you would have taken it off, it would have fallen out like a waterfall. Because that glass was completely shattered inside that door. Why? Because look where the bullets hit on the door. And if that window was up, you'd have an entirely perfect window still on the door, wouldn't you? Jordan Davis's shots are lower than Tevin Thompson's door. And if the window was up, you'd still have a window up. And you don't. You have lack of evidence, conflicts in evidence, and reasonable doubt. Not because I want you to believe it, because you can't hide from the truth and the facts of the state's case. You can't hide from the truth that detectives told my client. If somebody was trying to get out, this would be a different story. If somebody tried to get out threatening you, this would be a different story. Well, guess what? When you go back into that jury room, I want you to check box number 4, not guilty. Because that is a different story than what you heard. That is a different story than what you saw on that stand. That is a different story from every piece of exhibit presented. And Judge Healy's going to tell you that it does not matter how many witnesses the state calls, how many exhibits they put in. That doesn't matter. We talked in jury selection. We talked about that. If they call 100 people, does that mean anything of guilt? Absolutely not. You have to look at the testimony and the evidence, and that's our law. And Judge Healy's going to tell you that's our law and our instruction. Judge, if I may move, Your Honor.
Yes, sir.
Now, let's look at our dummy here. Remember Miss Wolfson pulled this in front of you and tried to say this is how he was shot? You remember Dr. Simons, a medical doctor, not a ballistics expert, not a firearms expert, a doctor, a medical doctor who does autopsies. And what did she tell you about this shot right here? Now, I didn't manipulate this. I didn't touch it. This is the state's evidence, and Miss Wolfson showed it to you. What did I ask Miss Pagan, the state's forensic expert for firearms, the ballistics expert? Did you see Miss Pagan touch this thing and testify to it? Did the state call a ballistics or firearms expert to talk about this? No. The lady who did the autopsy they called in. Tell me how this shot doesn't defy the laws of physics. Look at it. How does Jordan take a shot to the inside thigh if his leg is like that to explain this? They bring in the medical examiner to talk about firearms and bullets. And what did I ask Miss Pagan, their expert? Do bullets make right turns? No. Do they make left turns? No. Do they go up or down? No. Even if they hit something and ricochet, once they ricochet, can they turn? No. Look at the photographs. Look at the evidence. There's a picture of Jordan Davis laying on his belly. And you will see how high that gunshot is to the back of his thigh. Tevin Thompson, Tommy Storns, Leland Brunson, every officer on scene said Jordan Davis's feet were straight and he was hunched over like this. Now, some said he was in Leland's lap, but Tevin Thompson and another witness said he was actually leaning against him, up, feet straight. Now, what did the medical examiner say to the state? I really don't like using bendy. I'd rather show you on myself. And what did she try to show you? This is how she explains the shooting. Is this feet straight? Do you think Jordan's legs would be straight if that was the position? And how many times was she asked to assume to give you her expert testimony? Why didn't the state call the ballistics expert to testify to how bullets travel, other than it defies the laws of physics? And I got her to admit, and an expert knows this, especially a medical doctor, garbage in is garbage out. If somebody gives you bad data to put in, and you make a medical decision on it, that's a bad medical decision, right? It's not based on accurate information. It's not scientific. And Judge Healy's going to instruct you that you can look and determine for yourself with common sense if Dr. Simons knew what she was talking about, and she doesn't. She could do the autopsy. She can tell you how he died. And Miss Corey got caught off guard, didn't she? Do you remember her asking Dr. Simons, can somebody have a perforated aorta and still move? Yeah. You mean they'll still be living after that? Yeah. But it's catastrophic. You'll die very fast. Well, yes, without medical attention, you'll be dead pretty quick. Not in a snap. But she did say they move. So her own expert says that Jordan Davis could be jumping into that truck, still be shot, and still try to move. But nobody in that truck says anything other than Jordan Davis was sitting straight with his arm up. Because that's what Leland said. Remember his best friend? Remember he said his legs were straight, arm is up, and he's yelling at Mr. Dunn like this? Tell me how those shots work. And look at the dowels. Look at the state's evidence and pictures they showed you. The dowels are going down. Technician Kipple tells you what a great guy he is and a technician, that he had this course years ago. For 8 hours, they taught us about dowels. And I can render my opinion. I'm going to tell you, look at the dowels. They're actually down. Well, we know that's impossible because every witness, including Mr. Dunn, said, I'm sitting in my car firing out the window from a Jetta to an SUV. So how can the dowels in the back come down? It defies the laws of physics. And look at the picture that Technician Kipple takes from above. Remember I asked him about his angles? What did he say about Jordan Davis's door? What did he say about that one shot that's perfectly clean? It was almost a direct hit. And the other two were a slightly off to the right angle. And those were his words, not mine. Direct hit, slight right angle. Now look at the three in front with Tevin Thompson. They're all on a right angle. All right? Do you remember those pictures? All the doors were closed, weren't they? Does that make sense? How can Mr. Dunn reach his arm all the way around the side and shoot from his back window directly into Jordan Davis's window? He can't. It's physics. It's the law of the universe that can't change. This isn't the Matrix. Bullets don't move. They go straight. Now, take that back door. Open it up. Watch those dowels line up perfectly. The front door was closed for Tevin Thompson. We know that. But if you open Jordan Davis's door, those dowels will swing to a right angle, which shows Michael Dunn never moved his gun, never shot directly into the car, because he couldn't. He was in front of it next to Tevin Thompson. Why would the state not show you those photos? Who showed you open photos of the bullets? I did. I brought the technician in to talk about it. Why? It's not our burden. We have nothing to prove. But the state can't change the law of physics. No matter how much their witnesses try to, they cannot change it. Now, the child locks, not an assumption. We know for a fact that the child locks were not engaged, which means Jordan Davis had every chance to get out of that car, like Mr. Dunn said, and he did. Because do you remember me talking to the medical examiner on that stand? And I said, if somebody is up like this, does it look like they're in an anatomically sitting position? Yes. And if I'm leaning in like this, do you now have a shot at my ribs? Yeah. Can you go underneath my scrotum? Oh, you'd have to lift your leg a little higher. We're talking millimeters. But their expert agreed. And then what did I ask her about the Durango? Mr. Davis is 6 feet tall. If you put him next to that Durango standing, going in, oh, I can't testify to that. I don't want to do that. Why? Nobody gave me those variables. Nobody gave me those heights. Well, where'd you get your first ones from? Law enforcement. And did you take it at face value? Yes, I did. Garbage in is garbage out. Bad facts in is a bad opinion out. And why? Because the state knows you can't defy the law of physics, and you can't hide from the truth, and you can't hide your evidence as much as you want to do with pretty displays. It doesn't work. That doctor never was given the variables of my client's car, his position, and Jordan Davis standing outside that vehicle going in. Why? It's not my client's burden. And they better not stand up here and say it's not their job. Now I'm going to talk to you a little bit about justifiable use of deadly force. His Honor is going to instruct you, and it's pages 25 through 28 in your instructions, and you're all going to get a copy. And I ask you, when you go back in the jury room, go all the way to page 25 and start there. Because the law is going to tell you very clear. It is a defense to each of the 5 counts in the indictment and all lesser included offenses that the use of deadly force is justifiable if Michael Dunn reasonably believes that the force was necessary to prevent either an attempted murder of himself or another. Hear that? An attempted murder of himself or another. Any attempt to commit an aggravated assault, an aggravated battery, an attempted murder upon him or another. And you get a definition for an assault. Judge Healy's going to tell you that the law is that an assault is an intentional, unlawful threat by word or act to do violence, which creates a well-founded fear. And an aggravated assault is an assault using a deadly weapon without intent to kill. And the laws in this state of Florida is if you reasonably believe that, you have to find Michael Dunn not guilty of every count in the indictment, every lesser included. You don't even start your discussion if they met their burden of beyond a reasonable doubt. They cannot even get to a discussion of the crimes if they can't get past the justifiable use of self-defense and deadly force. And remember, these are attempts, because it says right there in the law, an attempt, any attempt to commit. A battery is when a person attempts to touch or strike another person against the will of the other. An aggravated battery is a battery where you use a deadly weapon. And Judge Healy's going to give you the definition of a deadly weapon. It doesn't say, we had to show we had a firearm, we have to go prove it, we have to go find it, because guess what? It's gone. That weapon in that car has been gone since minutes after it happened. And even if it was the next day, it's gone. A day after that, it's gone, because nobody looked for 5 days. It'll also tell you, and Judge Healy will instruct that this is the law, any attempt to commit an ag assault, an aggravated battery, attempted murder upon him in any vehicle occupied by him. On the next page, Judge Healy is going to tell you also that Michael Dunn is justified in using deadly force if he reasonably believes that such force is necessary to prevent either imminent death or great bodily harm to himself or another. Think about that. Great bodily harm. Our burden is not that you have to believe he was going to be killed that night. The state has to prove beyond a reasonable doubt that Mr. Dunn did not reasonably believe that he was in fear of great bodily harm or imminent death. Not both. Judge Healy is going to instruct that the imminent commission of either an aggravated assault, an aggravated battery, attempted murder, a murder upon himself or another is included in this. And you have the definitions. All of the law will be in here. You will see what I'm telling you. You'll get to read it for yourself. You'll get to feel it. You'll get to take notes. And Judge Healy's going to tell you that you must judge him by the circumstances by which he was surrounded at the time. That the danger facing Michael Dunn need not be actual. That the appearance of danger must have been so real that a person under the same circumstances would have believed that the danger could be avoided only through the use of the force that he used. Michael Dunn must actually believed that the danger was real. That's the standard. That's our law. And whether you like the law or don't like the law, you have to use the law. And that blanket, that flag, wraps around this man until the state can prove beyond a reasonable doubt that it was not self-defense. Remember, we talked, they have two burdens, and I'll get to it so you believe me. But they've got to overcome two beyond a reasonable doubt burdens. They've got to climb two mountains before you can convict Michael Dunn of anything. His Honor will further tell you that if Michael Dunn was not engaged in an unlawful activity and was attacked in a place where he had the right to be, a public parking lot, asking for a common courtesy, saying thank you, trying to tell the guy, hey, I said thank you. He had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force. And you will get the entire instructions. You'll get to read every word for word. Again, you'll have your own copy. And it will go through all of the attempts. And don't remember, it's not just the crime. It's an attempt to commit the crime. If the state can't prove beyond a reasonable doubt that Jordan Davis didn't try to attempt an aggravated assault, you have to find Michael Dunn not guilty. If the state cannot prove beyond a reasonable doubt that Jordan Davis did not try to attempt an aggravated battery, you have to find Michael Dunn not guilty. If the state does not prove beyond a reasonable doubt that Jordan Davis did not attempt to try to commit attempted murder of Michael Dunn, you still have to find Michael Dunn not guilty. And you heard Ms. Wolfson read you the standard of reasonable doubt. It's not a possible doubt. It's not a speculative doubt. It's not an imaginary doubt. Such a doubt must not enter your mind and your judgment. Because they're going to use that standard when they get up on rebuttal, because they get to talk last. I don't think it's fair, but I don't make the law. When they get back up, they're going to tell you, Mr. Stroll wants you to imagine it, speculate it. He wants to force you to believe it, and that's not a reasonable doubt. Watch. I guarantee those words are coming. But that's their burden for justifiable use of deadly force. And it's in black and white, and it's the law. It's not because I wrote it. It's not because I like it. We're not here to change it, and we're not here to fight it. We're here to apply it. And Judge Healy will tell you, here it is. If in your consideration on the issue of self-defense, you have a reasonable doubt on the question of whether Michael Dunn was justified in the use of deadly force, you should find Michael Dunn not guilty. And I'm going to read it to you again, because there's a double negative in there. If in your consideration of the issue of self-defense, you have a reasonable doubt on the question of whether Michael Dunn was justified, meaning, is it possible he used self-defense? Is it speculative it's self-defense? Maybe yes, maybe no. What does your verdict have to be? Your verdict has to be you should find Michael Dunn not guilty because the state has not proved beyond a reasonable of doubt, and as Mr. Guy said, beyond any doubt in his opening, you still have to find Michael Dunn not guilty. Just a few more minutes, Your Honor.
Yes, sir.
Thank you, Your Honor. And I apologize for being long-winded, but again, I don't get a second chance to talk to you. This is it. When I sit down, I'm done. And I can assure you that when someone from the state gets up, I'm going to be screaming inside my head that I want to rebut what they're saying, that I want to get back up and say, no, listen to this, look at that. But I can't. Again, I have to follow the same laws, and they get to talk last. So let me leave you with this. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of the evidence. Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. And the evidence is on that stand. Judge Healy will further instruct you that law enforcement does not mean that his or her testimony deserves more or less consideration than any other witness. And an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. Why would you have a medical examiner testify about forensic ballistic evidence? They called a forensic ballistic expert, Miss Pagan, and never asked her a single question about a dummy, about travel. Because why? She would have told you that their bullets don't defy gravity or change the law of physics. His Honor will instruct you, did the witness have an opportunity to see and know the things about which they testified? Not one witness told you anything that happened before the first shot was fired, except Tevin Thompson, Leland Brunson, Tommy Storms, and all of their stories don't match. Look at your notes on that evidence. Look, one says they got out, one says they didn't get out. One says both got out. One says I'm not sure they got out. I don't know where he went. I'm not sure where he went. I wasn't looking for him. Did the witness seem to have an accurate memory? You saw the state's own witnesses change their testimony before I even got up on cross-examination. Was the witness honest and straightforward in answering the attorney's questions? If I ever gave up law, I would be a dentist because I had to pull teeth of almost every witness from the state. I had to ask 3 or 4 times to get a simple yes or a simple no, or yes, that's true. Why? Why would they evade my questions and not the state's? Did the witness's testimony agree with the other testimony and other evidence in the case? No. Mr. Davis told you that even days later, before they gave their second interview, they still had little differences. They still were off. And again, the state's going to tell you that's okay. They're human. They're not professional or experts, but they won't hold that standard to Michael Dunn. It's okay for their witnesses to be in shock. It's okay for their witnesses to be in fear. It's okay for their witnesses to be scared for their life, but not Michael Dunn, because his blood was boiling. He's a madman with a gun, on the loose with a depraved mind, wasn't he? Did the witness at some other time make a statement that is inconsistent with the testimony they gave in court? How many times did I have to talk to witnesses about their deposition? And isn't it true you told me this? Isn't it true on that day you said that? You get to use that in deciding, were they telling you the truth or were they trying to evade my questions? Judge Healy's going to tell you that you may rely upon your own conclusion about the credibility of any witness. You may believe or disbelieve any portion of it. Now, His Honor is going to instruct you, and he's going to tell you that a reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And that's only if you believe the state met their burden beyond a reasonable doubt that Mr. Dunn did not use self-defense. Then you look at their case. And let's just assume, because Ms. Corey got to say it again, let's just assume they're going to come up and tell you how they overcame their burden beyond all reasonable doubt of self-defense. What does an abiding conviction of guilt mean? Abiding means forever. Permanent. Stands the test of time. So before you can find Mr. Dunn guilty of anything, in the words of John God, you need to go home, lay your head on a pillow, and never consider your verdict again. It has got to stay with you for the rest of your life and be permanent. Because in a month from now, a year from now, or 10 years from now, you can't call me up, say, had I known that, had I thought of that, I would have never found Mr. Dunn guilty. You can't call Judge Healy up and say, oh, you know what? Looking back, I'm just not comfortable with what I found him guilty for. Mr. Dunn's day is today. Mr. Dunn's time is right now with you. And unless you have an abiding conviction of guilt, you cannot find Mr. Dunn guilty of anything. And there is only one lawful, just, and righteous verdict, and that verdict is not guilty. Thank you. Thank you, Your Honor.
Yes, sir. Thank you, Mr. Strolla. Ladies and gentlemen, we'll take a break. Let's break for 15 minutes till 2:45. Don't discuss the case among yourselves or with others. We'll see you back in about 15 minutes.